Hello and welcome to graphic.com.gh, and from the Graphic Online TV newsroom, this is a brief.
The powers of the court can never be questioned at all. The court can call into question any act or omission of any person at all, insofar as it's in violation of the Constitution. So the contention by my left friend, counsel for first defendants, that it was an administrative decision of the speaker. And so, with all respect, I'll ask, and so what? Any administrative decision of a person or authority which comes in contravention of the Constitution is amenable to the court's judicial review powers. I strongly submit that the application before you is totally offensive to all rules and procedure of this honorable court, is unknown to the laws of Ghana, and must be dismissed. I pray accordingly.
Adding the point that the Chief Justice was privy to a constitutional breach. I think that's the point it was.
Oh yes, but the point is that if she was privy to it, her ruling must reflect that. If it doesn't, it's one of the grounds upon which I'm urging the court to set it aside.
The objection is therefore misconceived. Move your application and dismissed.
Graphic Communication is giving you the opportunity to have news not only in hard copy but also in a digital form. Download your Graphic News Plus now. Graphic News Plus, connecting people through news.
And that was from Supreme Court, where the case of declaration of 4 parliamentary seats vacant came up for hearing today. The jurisdiction of the Supreme Court has been invoked in relation to Article 97 of the 1992 Constitution, which deals with how the seat of certain members of Parliament can be declared vacant.
So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7 January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance, arising from the outcome of the ruling, weighed on the mind of the Supreme Court to grant an order directing a stay of execution of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the 4 members of Parliament is the current second Deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved. If the parties had complied with the court orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
Before the court moved into details of hearing the case, the Speaker of Parliament, Alban Babin, through his lawyer, Thaddeus Sori, raised an objection to one of the judges, Justice Gaewu, being on the panel. His reason was that Justice Gaewu once contested a parliamentary election on the ticket of the New Patriotic Party in the Volta region, and therefore he should recuse himself from the panel. But the Supreme Court overruled that objection and held that recusal on such ground will not advance the administration of justice. The court explained that there was currently a judge who was a former sitting member of Parliament, while another one is a former General Secretary of the People's National Congress, PNC. Again, the court held that the current matter was a subject of constitutional dispute and not of a political party.
Of the president arises from some of
that, my lord, on the extreme what?
Right to my lady the Chief Justice, to him being impaneled in this matter arises from the fact that at a point in time he was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you
proceedings
said,
and the
no, I think you said enough. Kindly resume your seat.
Very well, my lady.
To the preliminary objections raised to paragraphs 21 and 49 of applicant's affidavit will be addressed in the final ruling on this application. On the objection to a panel member being a former member of a political party, this court must take judicial notice of the fact that within the ranks of the superior courts is a former member of parliament for the National Democratic Congress, a former general secretary of the People's National Convention. It should be well understood that when Parliament approves a qualified citizen to be a justice of the superior courts, pursuant to Article 1284, the representatives of this country have appreciated the ability of that qualified person to contribute to justice delivery in the country. Second, the subject matter of this suit before this court is a constitutional dispute and not a matter involving political parties. The objection is therefore misconceived. Move your application. And dismissed.
And also before the Supreme Court was an application by Speaker of Parliament asking court to vacate its ruling that held the Speaker's declaration of 4 seats in Parliament vacant. In a ruling, a 5-panel of the court held that the Speaker's application amounted to a misinformation and misapprehension of the law. According to the court, the Speaker's submission that court had no jurisdiction in the matter was misconceived because the matter in question was clear case of constitutional interpretation. It is therefore misinformation and misapprehension of the law for applicants who represent that the Supreme Court has no jurisdiction to give interpretation on the provision of Constitution that has attracted 2 different meanings, the court held.
Where an issue that relates to matter or question referred to in clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination. And the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court. This means that if anyone finds that a meaning is being given to any provision of the 1992 Constitution that the person disputes, or that any act is being done by reason of a disputed meaning given to the Constitution, then Article 2 and Article 131A mandates that only the Supreme Court has jurisdiction to provide the people of Ghana with a correct interpretation of the provision in the Constitution. Third, it is the most basic tenet of our legal system that different courts operate in different jurisdictions, and every court is given its own jurisdiction. So the type of cases that can be settled in any court depends on the nature of the dispute. Thus, if someone is challenging that a member of Parliament has not lawfully won their seat, that challenge must be done at the High Court in the region that the constituency is in. However, if any two people challenge that the process of electing the same member of parliament did not conform with the constitutional provision, that dispute over the correct interpretation or meaning of the constitutional provision must be brought to the Supreme Court for interpretation. Indeed, if the dispute over correct interpretation or meaning of the relevant provision occurs while the parties are before the High Court, the High Court must, by direction of Article 132, stop hearing the case and refer the dispute over the correct interpretation of the Constitution to the Supreme Court. There are many cases on this manner of resolving disputes requiring constitutional interpretation, including ex parte Senator Rawlings, citation provided. In every given month and year, the Supreme Court regularly deals with cases seeking interpretation and enforcement of provisions of the 1992 Constitution. And every law report issued every month is filled with such cases. It is therefore misinformation and misapprehension of law for the applicant to present that the Supreme Court has no jurisdiction to provide the correct interpretation of Article 97(1)(g), because Article 99 gives jurisdiction over determination of membership of Parliament to the High Court. Your question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
After hearing some of the parties made these comments.
Today's ruling has narrowed down the issues for determination by the courts. In the sense that the first defendant, that is the Speaker of Parliament, now has no excuse whatsoever to decline or fail to file his defense and statement of case to the action. So now we are poised for a full hearing and determination of the matter. No more interlocutory or interim applications. Plaintiffs in the matter, we acted out of abundance of caution, in that we sealed the office of the Speaker. We did not seal the Speaker personally. My client, the majority leader, has no personal action against Right Honorable Alban Babin. It was his office and the conduct of some official matters, especially his ruling of 17th October 2024, which he objected. Now, back to your question.
Yeah.
The Speaker or any other arm of government or agency of government for that matter, by Article 88 of the 1992 Constitution, is mandated, I place emphasis on that word, is mandated to engage the attorney lawyer as its counsel in representation, whether in court or outside court. The circumstances under which they brought a private lawyer as their counsel cannot be answered by me. I leave that to them. But under the Constitution, going strictly by the express tenets of the 1992 Constitution, whenever any state organization or any arm of government is involved in a litigation, that entity is supposed to be represented by the Attorney General. So it's not a matter of me giving credence to the submission of the Attorney General on that score, but that actually is the dictate of the law. We acted out of abundance of caution by suing both the Speaker of Parliament and the Attorney General, so that whichever way they will be looking at it, the two of them will be in court.
Right. Very different, the Speaker of Parliament without any basis whatsoever. And I think it's very important to indicate that this country sometimes is a lot of ignorance paraded as wisdom. The situation where you have ignorance paraded as wisdom must stop. There's a lot of deceit and misrepresentation of reality to the public. You find all the points that have been made all the time. I listen to the radio quietly when this matter came. I've never spoken at all. And I see a lot of ignorance and mischief being perpetrated and being thrown in the eyes of the public. And you've seen it. I'm sure that is why the court took its time to deliver such a comprehensive ruling to educate the public properly and to prevent ignorance from being further paraded as wisdom in this country.
Away from Supreme Court, the campaign as part of election 2024 keeps heating up week after week. This week, whether or not there should be a debate between the two leading candidates, John Dramani Mahama of NDC and Dr. Mahmoud Bawumia of the MPP, is up. It started with Mr. Mahama posing 5 questions to Bawumia. Let's watch what Mahama said.
He posed 170 questions to my Vice President, Emisata. He should go and answer the 170 questions himself. Indeed, he shouldn't answer 170 questions. He should answer only 3 questions. 3. Why is the exchange rate 17 cedis to the dollar? Question 1. Exam, he should come and write. Ezu. Why has Ghana's debt risen from 120 billion to 767 billion in 8 years? Question 2, you should come and answer. Question 3, why is inflation where it is? Why did it rise to 54% under your administration for 8 years? And then let me add 2 more. Question 4, why did you borrow 42 billion cedis from the Bank of Ghana? Why did you borrow 42 billion cedis from the Bank of Ghana? He should come and answer those questions. We don't need 170 questions. 170, if he wants, he can answer them himself. But Ghanaians are asking him 4 questions. He should come and answer those 4 questions and explain to Ghanaians why we are where we are. The last question is, why has he run away from the economy to digitalization? He used to do big about economy. Today he can't mention economy. It's not in his vocabulary. Anytime he opens his mouth, digitalization. Come and talk about the economy. That's question 5. 5 questions. Tell him. He should come and answer them.
In a quick response, Dr. Bawumia answered 5 questions with 50 questions he posted on social media. That did not end there. President Akufo-Addo supported Dr. Bawumia on his campaign rounds in Ahafo region and said Mahama cannot compare himself to Bawumia.
Mahama said on your debate ne enyechna. If you say Bawumia enyeni tipen. Hey sir, on your class. Me to me who class people we are. You are Mahama Wumwa. Bawumia me who class go. But the class wa ko aminim. Class ba ko aminim. You are Mahama Ewomu. Class fifth time I say 4th Republic 1993. For enum in a Ghana for when a new yam a pension or Babetsna, Benua Kessia, Yakuna Kessia, President, Akunanos, for enum, Bako, Edia, Yakupa Man, Quaman, and me, and a friend of mine in Chang, a year you are Professor Mills. It's 4 Nakano. Nipa Bako Pet. Nipa Bako Pet. And a Ghana for. Show na juma so on there be ora o ade there and so any and koyie titasa it is say ora Mahama also was class here na yes our class of 1 ah no kwa no was our class no na enye class a me pese Bawumia e ba be class our class no the B Bawumia nyakopom Emma Coin of Froconano 7th January, or better was review, or better review. Wabaka Rollins, Kufo enemy so Mahama, there are no 1-term presidents, no dear, near no any about Amai Bawumia. And it's a son of person, it's a class of 1 or woman, ain't you know, ultimately Bawumia, and a ponso and Casa. Well, na Esonwara, you don't say. Yet Yasia so Say, class of one also there. And yeah, the papa. I will need classmates. Residential candidate, I would only classmates. Uncle Nam. Yeah, no near between the Ababa Yajuma. Ghana phone the Madukuntia. A man here, Uncle Nam. A Juma obey no, and saw any. Anything a man a chance, no. Now I say, I feel the Aquafana baby. I feel the Aquafana baby. A day, yes, sir.
But in another quick response, Mr. Mahama, who was in Savlugo on Wednesday, rebutted and said Bawumia should just go ahead and answer the 5 questions instead of posing 50 questions, which is not what Ghanaians were interested in.
We used to learn what they call nursery rhymes. And that one, you just have to learn it by heart. Even when you are sleeping, you should be able to repeat it. So if you remember, ba, ba, black sheep, have you any wool? Then we had Humpty Dumpty sat on a wall. Humpty Dumpty had a great fall. Those nursery rhymes. I woke up this morning and I saw 50 questions to me. It looks like our vice president has just learned those things in the 50 questions the way we used to learn Baba, Black Sheep, Humpty Dumpty sat on the wall. Because I asked you 5 simple questions on the economy. That's all. Simple questions that Ghanaians want you to answer. You go and respond with how many compost plants did you build, how many this did you build. That is not what the issue is in Ghana today. Let me take you down memory lane. In 1992, there was an election in America. It was between Bill Clinton and George Bush Sr. At that time, the American economy was in recession, the way the Ghanaian economy is in crisis today. And people were talking about immigration, talking about all kinds of useless things. You know what the Clinton people said? It is about the economy, stupid. Today, I'm repeating those words. This election is about the economy, stupid. It's not about all those other useless things about who built how many compost plants. Answer the 5 simple questions. And you can't hide behind the debate. You don't need the debate to answer the 5 questions. When you ask Emisata 170 questions, you did not agree to go and debate for him to answer them. Ghanaians are asking you 5 simple questions. Just answer them. Akufo-Addo too, I've given him 2 questions. He should come and answer them. That's all Ghanaians are looking for. You have destroyed the economy. That is the truth. Even if you look at the 50 questions he asked me, he has skillfully avoided the economy. There's nothing about the economy in those 50 questions. And that's why I gave you the 5th question. Why are you running away from economy? Because you were brought in to fix the economy. The economy is in a terrible state. Just answer the 5 questions I have asked you on behalf of the people of Ghana. Simple.
Thank you for watching. For more news, please visit our website, graphic.com.gh, and follow us on social media. Our handles are Daily Graphic Ghana on Facebook and Instagram, Graphic Online Ghana on TikTok, and Graphic GH on YouTube and X. My name is Arabna Kalba.